All right, and for the record, we're scheduled for trial commencing Thursday, April the 2nd, for 2 full days that are marked out, that have been marked out for quite a while
Yes,
for
Judge.
trial of this matter. Um, there's been ongoing motions and objections as it relates to the party's prior history in Texas. Mr. Goodrich still lives in Texas. The petitioner was allowed to leave Texas and come to Kansas with a minor child. The Texas action was dismissed. I've had this case for a while now, and it is scheduled for trial. There's a current motion for order for mother to undergo psychological evaluation, continuance of trial. And then there's petitioner's objection to respondent's motion for evaluation and a continuance of the trial.
And Judge, we can just dispense with her other motion, respondent's other motion to have witnesses appear via Zoom. I'm not objecting to that. Your Honor had said we could do that with other witnesses. What I would object is if it's for Mr. Goodrich himself.
Right. Yeah, and I do think there's a distinction between a party availing themselves to the jurisdiction of the court and witnesses testifying. So we're good with that. The physical and mental examination requested pursuant to 60-235. I don't think I need further argument. I think you can both stand on your motions. And petitioner filed a motion in limine, which not only objects to a new exam or an examination, mental examination being ordered, but objects to the prior exam out of Arizona not to be allowed admissible, or any of the deposition testimony with regard to that psychological evaluation. There was some question during the deposition itself, because I visited with both counsel on where that psychological evaluation came from. Apparently, from what I can ascertain, is it came from her other ex. Now, this is a paternity case, so these two were by both admittedly not married, but produced a child. This is a relationship of an older child of hers with a different man who has custody of that child.
The courtroom lights up as the trial officially looms. The judge confirms the schedule, 2 full days of custody battle, and motions begin flying immediately. Right away, tension rises around a psychological evaluation. Is it relevant, or just a tactical distraction from a decade-old Arizona case? The judge cuts through the fog, insisting the focus must remain on the child's current best interests. From objections to clarifying prior cases in Texas, this is where the chessboard is set, and each attorney begins calculating their opening moves.
Who's almost 18 in Arizona. So I'm going to be honest with you, counsel. I am not inclined to continue this matter any further. I've tried several times to do it, Ms. Gehring, because I knew you had a lot of catch up to do. And I did want you to be able to explore what all happened in Texas. I'm not sure that I anticipated Arizona. And I just don't think that the fact that she had a psychological evaluation over 10 years ago in Arizona on a different case with a different child, with a different father, lends itself to a good basis now to have her re-examined. I'm not aware of allegations of her suffering from chronic depression and not tending to the needs of the child, or any other kind of psychiatric evidence of perhaps instability. It's not to say I can't order one down the road, but in anticipation of this trial, I just can't see where it's necessary. And honestly, if you just from a relevancy standpoint, I think its prejudicial effect outweighs any probative value that that old exam, that old assessment would have. And I did indicate, and it is true, what I'm focusing on now is current parenting abilities and skills, and who provides the statutory required factors and additional factors that should have primary residential. And we only need primary residential because we've got two parents in two different states. So we got to have a primary residential parent. So I'm going to deny at this time your request for an examination and deny your request to extend the trial date, to continue the trial date. And so the only thing that remains at issue is not so much what happened in Arizona, because as it was mentioned by Ms. Huntington, I think it's a good point. Your client produced a child and spent a vast majority of his relationship with her after the whole Arizona situation, where he had plenty of time to have his own personal observations and things that if he wanted to present to the court, he could have asked for this much earlier if he thought it was a necessary evaluation that needed to be ordered by the court. So it's late. I don't think it's going to produce, certainly our old report, I don't think it's going to be probative. It'd be more prejudicial than probative. And I just don't think there's good cause to order her to be subjected to a psychological evaluation. I'm not continuing the trial. The question now is how much of the Texas matter are we going to get into that was arbitrated? And I still believe that if I address the psychological evaluation, that's clear cut. But I think everything else in Texas is just going to be subject to objection and ruling by the court at the time of trial.
Your Honor, I would like to lodge an objection to the motion in limine that was filed because
the courtroom heat escalates. Arguments intensify over whether the psychological evaluation is necessary. The judge's words land like a gavel strike. Outdated assessments carry prejudicial weight, not probative value. Lawyers spar over deadlines and procedural technicalities. While the stakes loom, delaying the trial isn't an option. Every objection, every counter, sharpens the suspense. The child's future hangs in the balance, and the attorneys are locked in a high-stakes duel of strategy and timing.
it's out of time. At the last hearing, Your Honor set a deadline for pretrial motions, which was March 27th at 5 p.m., and she files something at 7:30 p.m. on a Saturday. And it doesn't give me enough time with the other matters that I had scheduled today and yesterday to get ready for a motion in limine. And she's had time to file that and didn't.
Well, I didn't have time because you hijacked the trial and turned it into this, my client needs a psychological evaluation. I had to spend hours drafting a response to your motion that was filed 3 days before a hearing, 3 or 4 days before a hearing. I didn't have time.
Object to this, Your Honor. It has nothing to do with
Hang
her
on,
timing
let me-
of filing her motion.
Okay.
Everything's got to be personal by Ms. Huntington, and it needs to stop.
Okay, let me look here.
Judge, it was due on Friday by 5, and I worked all Friday night and Saturday on motions in this case, and I finalized it and filed it Saturday.
Well, it's made a part of the record. You've won as it relates to a examination and a continuance of the trial. But I believe that these matters that occurred in Texas are subject to rulings by the court during the course of the trial. If something's hearsay, or if there's a relevancy issue, or you know, a veracity issue, I think we're just going to have to deal with it in court. I don't think I can give you, I'm not going to give you a blanket motion in limine that says anything that went on that was investigated or considered or determined in Texas is, you know, out of bounds. I'm not going to do that. But I am going to try to keep us on track. And, you know, we only have 2 days for this. And I have made it clear, and I think you both understand and appreciate, even though your clients may think it's important to rehash things, that what we're looking at is the best interest of the child right now, and all of those factors. And there could have been a different decision in Texas, but there wasn't. And we are where we are. But I'm not going to eliminate the ability for them to raise something because it's objectionable because it was already raised in Texas. Because as has been pointed out by this attorney and I think the previous attorney, that was not a fully litigated on the record situation, and that we can go back to the court record and say, these folks had their day in court and they fully litigated custody. So, but I do think you're going to have to prove up, you know, if that arbitration was a somewhat closed proceeding, which I think it was, I don't know that it was confidential, but if that was a closed proceeding, there may be stuff that there's no way for either one of you to be able to logistically figure out witnesses and foundation to be able to, you know, introduce it or ask questions about it anyway. Because it wasn't a formal court proceeding where you would have a stenographer and a record and you can produce the record with the testimony of independent witnesses or that kind of thing. So it makes it a little tougher, I think, to use it for any particular purpose in our trial, but we'll just have to see how it goes. I'm denying the motion in limine.
Attention shifts to prior Texas custody matters, which bring layers of complication. The judge acknowledges past rulings, but makes it clear what happened then is secondary to what matters now. Attorneys try to leverage prior arbitration, but the court emphasizes relevance and admissibility. The tension builds subtly here. The audience senses the battle isn't just about law, but narrative control. Both sides preserve arguments for appeal, knowing the courtroom record will become a weapon if needed.
But you've got to preserve for the record.
Yes,
and you've got it preserved as you make your objections throughout the trial. And then obviously you've done your homework and you've done your work in this case to not only make your arguments for trial, but to preserve your record for appeal if that's what you want to do, if there's some reason to do that down the road. And I'm sure both counsel will tick every box, dot every I, and cross every T to zealously advocate for their clients and to preserve the record for appeal in the event that they're unhappy with the outcome. So, okay. Have you guys been able to exchange witness list, exhibit list? Are you just going to go off the pretrial conference?
No, Judge, I had emailed Respondents Counsel last week and said, can we talk about an exchange date? And I never heard a response.
Your Honor, we have exchanged exhibit lists. They were both filed with the court.
Judge,
on March 20th.
if you look at those, you'll see that it doesn't really tell you what the exhibits are. There's no way to go through them and say they're incomplete or nothing at this point.
Your Honor, based off the way this case has proceeded and the comments made by counsel on the record, I'm really not inclined to with some of these things that have been going on and the allegations made that I just would rather defer to the pretrial and what Your Honor wants us to do with exchanging exhibits. We've exchanged the list, the witness and exhibit list.
Well, if I didn't do a scheduling order that required you to do it 10 days in advance, then I can't hold you to it. And you're just going to have to rely on each other's pretrial representations, either by questionnaire or the actual order itself.
Well, can we have the exhibits before the morning of trial?
Well, anything that's, I would ask, well, you're asking me kind of late to do that. I mean, now you should be getting ready for cross-examination, opening statement. I mean, I don't know what good it's going to do for you at this point, but I would say I want you to exchange by 5 o'clock tomorrow anything in addition to what's in the pretrial order that you're intending to offer or admit. And then I can't control rebuttal. So that can always, things can always come up during rebuttal, but I'm going to try to cut down on your work by just saying anything you're doing in addition to what you contemplate and put in your pretrial, then that list needs to be exchanged by 5 o'clock tomorrow.
Judge, there was a scheduling order filed in this case, February 20th that you had me file, and it has a deadline of March 20th by 5 for the witness and exhibit lists.
So that was Friday too.
Correct.
And we did do that. We did lists, Judge. We did, but
Okay.
the actual exhibits themselves, I mean, I'm just used to having them before trial so that we can each take a look at them and know what to expect. But I hear the court's order.
Well, I usually have attorneys that get along a little bit better than you two are. So I don't, again, it's so late. If you want to compel it, file a motion to compel, you can, but I don't think we want to do anything to postpone this trial date. I can only do what I can. Thank you. I'm sure it was in here. I just wasn't finding it. I can only do what I can do, which is anything above and beyond what's already been identified in the pretrial order, you need to provide it to the other side. So there's no, these things are not supposed to be about ambushing each other. So, and you know that. So that's, and then if there's an issue about, I don't know, I don't remember how much discovery because there've been other attorneys that you've done, but if there's an issue with something that's produced that clearly was within the parameters of a discovery request that was not supplied or identified, then you can make an objection and ask that it, not be, that the court sanction the party by not allowing them to introduce the exhibit. If you have a good feel for your discovery stuff, that's all I know to do at this point.
Now, the drama turns technical, exchanging witness lists, exhibits, and pretrial preparation. The judge guides the attorneys through deadlines, procedural pitfalls, and expectations for presenting evidence. There's an undercurrent of suspense. Any misstep here could derail the case. The attorneys are balancing both strategy and logistics, with the courtroom becoming a chessboard of timing, tech, and tactics. Viewers feel the tension quietly mounting, knowing the trial itself is just around the corner.
Yeah, we'll just get started on time on Thursday, make the best out of our days. Ideally, I'd like you to plan your cases around the fact that you each get a day, so that we don't have any time issues at the end of all this. Obviously, sooner's fine. With good prep, you can make your points without needing a lot of time to make your points. But let's try to be mindful that we have 2 days and everybody has their case they want to present. Let's see. Man, I'm trying to remember where this all started. I think did it start with the petitioner filing and wanting temporary orders after it started with the UCC JEA issue. That's where it all started, when we were attempting to transfer Texas documents. And then once I realized that it wasn't a mistake that the case was dismissed, I really was concerned originally in this case that the clerk had mistakenly dismissed the case. But when I talked to the judge there in Texas, they were like, no, this case was just dismissed. They had an agreement and it was dismissed. So I think this was sort of filed as a new custody paternity type of thing. And initially there were some temporary orders that were asked for. And we're still trying to litigate final custody. So I'm sorry, counsel. I'm trying to figure out who has the burden here and who's going to go first. But I think it's the plaintiff.
Mm-hmm.
Yes.
Okay. So you're going to be calling your witnesses first thing Thursday morning.
Yes.
Do you have, for the sake of Amy, she's pretty good at doing hybrid, but we've been through like 3 or 4 or 5 different sound systems in the last 4 or 5 years. And things don't always work according to plan. If she has a good idea who and when, it's helpful to her so she's set up, especially if she's going to be displaying or publishing any exhibits to the witness during the trial. So I guess I'll start with you, Ms. Huntington. Do you have any, who will be your Zoom witnesses if you have any?
Yes, Judge. The 2 teachers, I don't have my list in front of me.
Okay.
And we have 1 lay witness that she just recently had a baby, and so she's going to appear via Zoom unless the court requests that she be in person.
Okay, and then who do you have, Ms. Gehring?
Your Honor, I believe it will be 3 witnesses.
Do what? I'm sorry.
3 it's about 2 to 3 that would be by Zoom.
Okay. All right, so about the same amount. And Ms. Huntington, are either of these 3 going to be your first witnesses of the day?
I think I would probably try to do that. If it helps Amy for me to lump them together, I can try to get them back to back if that would work.
What I usually do is I'll just start the Zoom portion of it first thing in the morning. But if you also have any exhibits that are going to need to be presented to those witnesses, I will need to have those either emailed to me separately or I'll have to have them on a flash drive.
Okay, well, it sounds like she's prepared, and as long as you instruct her on the exhibits, then you can do them in whatever order you want to do them. And do you initiate will you give them, have you already given them a password and ID and password for this hearing? Have you designated one?
I don't know if I have sent one out. I don't even know if I recall there being possible Zoom testimony. I have a link that is designated just for Zoom testimony for any trial, so I can get sent over to them.
This segment reads like a modern courtroom thriller. Hybrid testimony and Zoom logistics dominate the discussion. who will testify remotely, which exhibits need to be shared, and how to avoid technical mishaps. Every decision carries weight. A wrong link, a missing exhibit, or an unprepared witness could tip the balance. The judge ensures order, while attorneys prepare for the digital stage of this custody showdown. The suspense here is subtle but critical. Technology becomes as much a battlefield as the arguments themselves.
Okay, yeah, do that. So, because then you let them make the arrangements of when they're ready for them, let them know, and then they have the information to just log in.
Correct.
Okay.
So I put the regular Zoom link in the subpoenas. So is it different than that?
Or I'm trying to find some of your subpoenas.
Yeah, like
For like Kelly Goodrich,
yeah.
Shandy Adams. I think that might be the recurring domestic, which if
I'm sure it is.
we can use
what we
that
use
one as
for
well.
here.
Yeah, we can use that one as well. I'll double check that, and
Okay.
if that's accurate, we'll just use that one
Thank you.
to keep from confusion.
But the only bad thing is we don't want people popping in, because a lot more people know our domestic link than they do the in-court trial Zoom link. But if
And
that's
it's-
what they've already been given, so that they are not, I bet you they'll check with you and still want to know how to log in. But
Mhm.
if you can find out if that does work, then that's fine.
It is the recurring domestic link. So if I just know ahead of time who they're calling, as long as they come into the waiting room and have themselves identified that way, we should be fine.
Okay.
Thank you.
All right. Anything else?
I don't believe so.
All right. If there's nothing further, we're adjourned till 9 a.m. on Thursday. Thank you. The
Thank you.
courthouse opens at 8. Security starts at 8. So they can unlock courtroom A, and you can come in anytime you want before 9.
Thank you, Judge.
All right.
As the session closes, the courtroom is a model of precision under pressure. The judge confirms logistics, Zoom links, and exhibit preparations. Attorneys and staff finalize plans, readying for the trial that will decide custody. The gavel hits, but the tension lingers. Everyone knows the next 2 days will be decisive. Every detail matters. Every testimony counts. And the courtroom transforms into a high-stakes arena where strategy, law, and human emotion collide.